Good afternoon, everyone, and thank you all for joining us for this criminal record expunction listen and learn. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. If you are unfamiliar with the format of this event, first we're going to watch an informational video on this area of the law. At the end of the video, we will have a question and session answer with one of our second chance attorneys. You can put your questions in the Q&A box on Zoom or in the comments section on Facebook at any time. We'll review all questions put in the chat boxes during the Q&A session. Please remember that this is a public forum and Legal Aid is not representing you. So please remember not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to go ahead and start the video. This presentation was created by Legal Aid of North Carolina. This presentation only provides legal information and not legal advice. The information presented is based on North Carolina law only.
What is an expunction? Expunction means to permanently remove an offense or a conviction from a criminal record. When an expunction is granted by the court, the public criminal record of the expunged offense or conviction is destroyed. Once somebody receives an expunction, they can truthfully deny that the expunged offense or conviction ever occurred. There are three primary types of expunction. There are the expunction of not guilty charges, the expunction of dismissed charges, as well as the expunction of convictions. We will review the three types of expunction. We'll start with the most common types of expunction, and then we'll get into the expunction of convictions. So the first type is the expunction of not guilty charges. Now these are all charges where someone was found not guilty of the offense that they were charged with. These types of charges are eligible to be expunged. Next is dismissed charges, and these are all charges that were dismissed. These are also eligible to be expunged. Now, most charges that are dismissed after December 1st, 2021 will be automatically expunged 6 months after they are dismissed. However, if somebody has dismissed charges prior to December 1st, 2021, they will need to file a petition to seek the expunction of those dismissed charges, and those types of dismissals will not be automatically expunged. All of that to say, if somebody has dismissed charges that were disposed of prior to December 1st, 2021, they are still eligible to be expunged. That person would just need to file the petition and file it with the court to seek that expunction, as opposed to most charges that are dismissed after that December 1st, 2021 date. Those will be automatically expunged from that person's record 6 months after the disposition. Now, let's talk about the expunction of convictions, and these are where somebody was found guilty or pled guilty to an offense that they were charged with. There are two categories of this type of expunction. There are what we call youthful convictions as well as adult convictions. Youthful convictions are also known as raise the age convictions. Now these are most misdemeanors and some Class H or I felony convictions that were committed before December 1st, 2019, when the person was 16 or 17 years old at the time of the offense. These types of convictions are eligible to be expunged. Adult convictions. These are some misdemeanors and few felony convictions when someone was 18 years old or older at the time of that offense may be eligible for expunction. Now, there are a number of what we call disqualifying convictions that could prevent somebody from expunging any of their adult convictions. Now, the law that speaks to the expunction of adult convictions includes a list of offenses that are not eligible for expunction, and the statute that speaks to that is listed on the screen. Now, if somebody has a conviction for any of these types of offenses, that person is not eligible to expunge any convictions that occurred when that person was 18 years old or older. However, that person may still be able to expunge any race to age or youthful convictions that they may have, and they are also still eligible to expunge any dismissed or not guilty charges that they may have. Some of the most common ineligible offenses include Class A through G felonies, such as common law robbery or the sale of drugs. We have Class A1 misdemeanors. The most common ones that we see are misdemeanor child abuse. Domestic violence protective order violations are also Class A1 misdemeanors. We have any convictions that require sex offender registration. We have assault offenses, so any offense where assault is an essential element of that offense. So, as on the screen, assault on a female, simple assault. If assault is in the name of the charge, it's likely going to be disqualifying. We have any offense that involves heroin or crystal meth. And then we also have possession with intent to sell or deliver cocaine, which we abbreviate to be PWISD cocaine. And this differs slightly from any felony offense involving heroin or crystal meth, because mere possession of those types of drugs is disqualifying, as opposed to cocaine, where felony possession of cocaine is not. There needs to be some further intent with cocaine in order for that to be disqualifying. And again, these are just the most common. There are a couple more on that list, but all of that to say, if somebody has a conviction for one of these types of offenses, what that means is that they are not eligible to expunge any adult conviction that they have on their record. Now, I'm going to walk through what the general expunction process looks like. This can vary in time, meaning it really depends on a multitude of factors how long this process can take. But generally, no matter what type of expunction someone is seeking, the process will look generally the same. And so the first step is obtaining an accurate and complete copy of the criminal record. In order to be able to move on to step 2, which is determining eligibility for expunction, somebody needs to make sure they are reviewing an accurate and complete copy of the criminal record that they are seeking to expunge. And so once somebody has that complete record, they can move on to step 2 and determine, based on what is on that record as it applies to the law, what may or may not be eligible for expunction. Now, step 3, if it is determined that someone does not have any offenses that are eligible for expunction, the process stops at this point. There are no further steps to be taken. However, if it is determined that somebody does have offenses that may be eligible for expunction, we continue on to the next step, which is to identify the correct petition form for that type of expunction. There are separate petition forms for each type of expunction, and these are standard forms from the Administrative Office of the courts. And so depending on the type of expunction relief somebody is seeking, there is a specific form that that individual would need to complete in order to get that process started. Now, once somebody has identified the correct petition form based on the relief they are seeking, they would want to complete it and any required documentation that may be needed depending on the type of relief they are seeking. That to say, when it comes to expunging convictions, there are supporting documents that are needed in order to support the expunction. And so that individual would need to not only complete the petition form, but also want to complete those documents and file those with the court at the same time. Once all of the petitions have been drafted and all of the supporting documents have been completed, the next step is to identify and follow any county-specific procedures for filing. And what that means is there are 100 different counties in North Carolina. And so there are 100 different ways that somebody could go about filing the petitions in the counties that they need to file in. And so depending on the counties that somebody is working in, they would want to reach out to that clerk's office to inquire about how best to get their paperwork filed as needed. Now, to this point, petitions for expunction need to be filed in the county and division where the expungable offense occurred. And what this means is, for example, if somebody has dismissed charges that are eligible in Wake County and Johnston County, that person would be completing at least 2 different petition forms, one for the dismissals in Wake County and one for the dismissals in Johnston County. Now let's say in Johnston County that person had dismissals in Superior Court as well as District Court. That person would be filling out 2 different dismissal petitions, one for Johnston County District Court and one for Johnston County Superior Court. And so when we say they need to be filed in the county and division where they occurred, that is an example of what that may look like. And so if somebody has a record that spans different counties and different court divisions, depending on the relief they are seeking, there could be a number of different petitions that need to be filed. Now, once somebody has filed all of the expunction petitions that they have worked on and are waiting to hear back from the court, again, how long that takes can vary county to county. But ultimately, by the end, that individual should receive the expunction petition that they filed, either denied by the court or hopefully granted by the court. And if the petition is granted, that means the expunction was granted by the judge. And so if somebody receives a granted order from the court, what they would want to do at that point is to verify that that expunction was certified. And what does that mean? There are public terminals in each courthouse where somebody can input their information to confirm that the expunged offenses no longer show up in that database. And that is the ultimate goal, because if somebody were to type in the file number of the expunged offense, it should no longer show, meaning that the clerk, upon the granting of that expunction from the judge, has gone into their system and deleted reference of that expunged offense from the public database. Now, to that point, again, to reference back to the beginning of this presentation, expunction means to remove the public criminal record of an offense or conviction. And so to that end, there are still certain agencies that are still able to access expunged records. However, as I will get into in the next slide, they can only access them for very specific purposes. So access to expunged records. These expunged records can still be accessed by prosecutors. So these are district attorneys. They can still see and use expunged records for sentence calculations. So meaning if somebody were to be charged with another offense and they are subsequently found guilty or plead guilty to that offense, district attorneys can look at expunged records that that person may have had in the past and can use those when it comes to determining the person's sentence for that new offense that they were found guilty of or pled guilty to. Additionally, they can also use it for what we call habitual offender status. So again, it's kind of the same concept. If somebody is charged with another offense, plead guilty, found guilty, district attorneys can use the expunged offense to determine if somebody should be classified as a habitual offender. The next entity that can see them are arresting agencies, and that is because they keep what are known as investigative records, and the database that they use is not available to the public. And so if somebody doesn't work in an arresting agency, they're not able to see or access those records. And so they are not required by law to delete expunged offenses from their investigative records. And one of the main reasons is because it's not publicly available. And last, we have law enforcement agencies, and they can see expunged offenses and records for employment purposes. So if somebody is seeking to become employed at a law enforcement agency, that agency can see expunged records if that is the case, if that person has any of those. And then additionally, for certification purposes. And so if somebody is looking to obtain some kind of certification within the law enforcement agency, they can also see expunged records for those purposes as well, in determining whether, somebody should be hired or if somebody should receive that type of certification.
This presentation was brought to you by Legal Aid of North Carolina. Legal Aid of North Carolina is a statewide nonprofit law firm that provides free legal services in civil matters to low-income people in order to ensure equal access to justice, and remove legal barriers to economic opportunity. Legal Aid of North Carolina offers listen and learns on several topics, including criminal record expungement, child custody, Medicaid rights and eligibility, simple divorce, Social Security disability, SNAP benefits, tenant rights, and wills and powers of attorneys. All right. Now that the video has ended, we're gonna open it up for our Q&A session. Today we have Trenner, who is an attorney with our Second Chance Project, to answer those questions for you. Please remember that while Trenner is an attorney, she is not your attorney. She cannot respond to specific legal questions. And so from that, I'm gonna get us started with our first question. Um, Someone is asking, in the case of the 16 or 17-year-old age, is I guess for the raise of the age, is it based on when the crime occurred or when that person was found guilty for raise the age
Oh,
purposes?
okay, great. Hi, Marissa. Hi, everyone. In the case of the petition to expunge charges committed when you were 16 or 17 years old, that is based on when the offense occurred, not the conviction date, the date of the offense.
Perfect. Um, okay, I don't know what that means. How does something that is guilty waiver by clerk, what kind of disposition is that? Is that not guilty? Is that guilty?
Okay, so that is still a guilty disposition. What that often is will be a situation where the guilty verdict occurred when the charge was paid. Sometimes that's for like a traffic ticket, or sometimes it's for like if someone wrote a bad check or something like that. Now, of course, I can't speak to what that specific offense is that that person is talking about because obviously I'm not looking at it. But basically, it just means you went to the clerk. Usually, it means that you've gone to the clerk, paid for the offense or paid the fine for the offense, and by doing so, you have admitted your guilt. So that is still guilty.
Perfect. Um, how long does the expunction process take if it's something that's not going through the automatic 6-month process?
Okay, so that's a great question, and that the answer to that is it can vary wildly depending on what district you're filing in. Some counties are very quick, some counties move much more slowly. It can also depend on what kind of charges you're expunging. For instance, if you're petitioning the court to expunge dismiss charges, the court can just decide on those. Where if you're petitioning the court to expunge convictions, the court is required to order a background check, which automatically causes the process to be more lengthy. So it just the short answer is it just varies completely depending on where you're filing, what you're filing, and how much you're filing. I've seen it take as little as a week for dismissed charges and as much as a year and a half for convict for charges as well. Again, it just depends on where you're filing.
Is a PJC considered a guilty verdict? I'm assuming you know what that means.
Yes, a PJC is a prayer for judgment continued, and that is considered a guilty verdict for the purpose of expunction.
Perfect. Someone's asking if they're filling out the expungement forms and they get something incorrect, do they have to, like, I guess they have to refile? Do they have to pay the fee an additional time, or is that how that works?
You know, I'm not sure that I can answer that question for sure because it might depend on what the error was that was made, and it also might depend on what the procedure is in the particular clerk's office where you're filing. It I would think that they might ask you just to update the petition, but if it's on the wrong form, again, it's just going to depend on what the procedure is where you're filing and what the specific mistake is. I'm not sure I can answer that um completely right now.
Yeah, no problem. I'm getting a couple questions here about how do tickets work as far as expunctions. I guess in a situation where a ticket might be showing up as a misdemeanor, do you have any information you could share about how, I guess, the traffic offenses operate in the expunction world?
Sure. I can share some general information about traffic offenses and expunction. First of all, an important thing to know is that there's two different types of traffic offenses. There are, like you're saying, misdemeanor level traffic offenses, but there are also what's called infractions. Traffic infractions are not eligible for expunction under the expunction statutes in North Carolina. So you cannot petition to expunge. And that would be a responsible verdict as opposed to a guilty verdict. If you've been found responsible of an infraction, that is not covered by the North Carolina expunction statutes. Um, as far as misdemeanor traffic convictions go, once they are a misdemeanor level traffic conviction, they do work like other misdemeanors. However, the difference is they can be excluded if you're trying to just do other types of charges, and that would depend on your criminal record and how you chose to proceed with the expunction. So that would really depend highly on what your particular record looks like, and what effect those charges would have on your waiting period to expunge convictions, or something like that. As far as dismissed misdemeanor level traffic charges, those are eligible for expunction the same as any other dismissed misdemeanor.
Okay. A couple questions asking about the filing fees. What are the filing fees, and is there option to get those fees waived?
There is. Okay. Filing fees are different for different types of expunction. The expunctions to or excuse me, petitions to expunge conviction, there's a $175 filing fee. I believe it is a bit less for the petition to expunge convictions at the age of 16 or 17. In any case, there is no fee, excuse me, for petitions to expunge dismissed charges or not guilty charges. So there is an option to ask the court to waive the filing fee based on your financial situation. That form is called a petition to proceed as indigent, and the form number is a AOC CRG, or excuse me, a G106, AOC G106. And that form asks for some information about your financial situation. And what you can do is you can submit a petition to proceed as indigent, the G106, with the petition that you're asking to have the fee waived for. Explain on the form the way that it asks, what your financial situation is, and ask the court to waive the filing fee based on your inability to pay.
Perfect. For those of you who have your hands raised, you cannot unmute in this forum. If you have a question, you need to put it either in the Q&A box on Zoom or in the comment section on Facebook. A couple quick people asking, where do we get these forms from?
Okay, so the forms are on the North Carolina, the nccourts.gov website. You can, if you Google petitions to expunge charges in North Carolina, you can get to their website, and that's where the forms are at nccourts.gov. Marissa, do you by any chance have the ability to put that link in?
I just did.
Okay, perfect.
So a link to the forums on the NC Courts website is in the chat, both chat boxes now. Can you file multiple? Lord have mercy. Can you file multiple expungements at once, or? And I think the other way to answer this question is also, can multiple charges be filed like all together?
Yes. That's a good question for a couple of reasons. Like Lorena explained in the video, it is necessary to file a separate form in every county, and then superior or district court in that county where the convictions or dismissals took place. If you are petitioning in different areas to expunge convictions, and under North Carolina law, you are required to you're only allowed one chance to expunge convictions, and you are required to file all of those forms within 120 days of each other. So it would be important to file everything, if not at once, within that period of time. This is where, if you have multiple convictions across multiple counties in North Carolina, this is where it would become very advisable, in my opinion, to consult an attorney about how you should submit those petitions to make sure that you do not fall outside of that 120-day period and cause yourself to be exempt from expunging some of your convictions in the future.
That let me see. Best way to ask these. I'm trying to group multiple questions together so you don't have to repeat yourself.
No, you're totally fine. Thank you, Marissa.
If something was expunged, I'm assuming this is a conviction in another state. If that was expunged in that other state, would that show up in North Carolina? I think that's what this question is asking. If you
So
can
when
answer that.
I'm not, I don't think I can answer that one because out of state convictions are a little bit tricky when it comes to expunction, and it depends very highly on what the conviction was, when it was, was it actually expunged in the other state. We would have, in order for me to answer that question, I would need to see the entire out of state record and the entire North Carolina record.
Perfect. Can you talk a little bit about, if you know this offhand, the time frames for after, I guess, sentencing or after whatever kind of money had to be paid for when you could file for an expunction, like after a misdemeanor, how long do you have to wait after a
I
felony?
can
Get a
I
couple
can give
questions
you
about
some
that.
yeah, sure. I can give you some general information about that. Again, though, this is another one of those situations where it depends very highly on your entire criminal record. So, and what you're petitioning to expunge. But if you're petitioning to expunge all together with all of your petitions put together, if you're only petitioning to expunge one, not one misdemeanor, that you can do that 3 years after the date of conviction. If you are petitioning to file, or if you're filing petitions to expunge multiple misdemeanors, those can be filed 7 years after the completion of the sentence of the latest completed sentence. If you're petitioning to file one felony, that is 10 years after the completion of the sentence on that felony. If you are petitioning to file multiple felonies, which you can only do up to 3, I believe, that would be 20 years after. There's a little bit of a different one for breaking and entering convictions. I believe that's 15 years after the end of the sentence. It's also important with felonies to understand that if you have 2 felonies, that more than one felony offense that occurred further than 24 months apart from each other, then those become disqualified because the felonies must be within 24 months of each other to be eligible for expunction. Another important point about all of those timeframes is that charges that were dismissed, charges that were dismissed or convicted on, or convictions that occurred on the same day of court, count as one charge for the purpose of expunction. So if you went to court one day and were convicted of 3 different things at the same, 3 different misdemeanors at the same time on the same day, those would count as one misdemeanor for the purpose of expunction.
Okay, perfect. Someone wants to clarify a a DVPO violation. That's not the kind of thing that can be expunged, right? They just want that clarified from the video.
That is not. If you were convicted of a DVPO violation, that charge is not eligible for expunction. And in addition to that, that charge makes any conviction that you have received over the age of 17, or excuse me, over the age of 18, is also ineligible. It is what is called a disqualifying offense. That's one of those A1 misdemeanors that Lorena was speaking about in the presentation.
And then I think it might be helpful if you could just go through for the raise the age. What are some of those offenses? Like, were they all misdemeanors that qualify for that likely qualify for raise the age? Are there some felonies that would qualify under raise the age? Getting a lot
There
of
are
questions with people.
Yes. For the rate, if an offense that occurred when you were when you were 16 or 17. There are some eligible felonies that go into that category, and there are also eligible misdemeanors that go in that category. I believe that the felonies, it is the same. There's nothing over an H or an I is going to be eligible under that statute. And but I do believe that a few more of the misdemeanors are, and I cannot give you the entire list off the top of my head.
For the one who's asking about DVPO, DVPO is a domestic violence protective order.
That's right.
Uh, Someone wants clarification. So expunged charges will not show up on a background check for employment. Is that correct?
Um, so it depends on what the job is that you're applying for. In a regular employment situation where you're applying for just at a private employer, the charges should not show expunged charges should not show up on that background check. Now, it's important to point out that different agencies take longer to remove records from their background check. So, for instance, the State Bureau of Investigation takes about 6 months after an expunction has been executed to remove their records. So, even though the expunction order has been granted, it may still be there for the sake of the SBI. If one wanted to look up on their SBI record, you can go to their website and request your own background check for that. There's also sometimes where private agencies that do background checks will have outdated records. They will not have updated their records. Occasionally, something that has been expunged will show up on one of those. If you have had an expunged charge show up on a background check at a private agency, you can contact that agency and ask them to remove that from their records. Um, and if you should be able to ask an employer, what they're seeing and where they got that record. Now, if you're applying for certain government jobs, like Lorena also mentioned in the video, if you are applying for certain government jobs are entitled to look at your entire background, even expunged records, for the sake of an employment background check. One of the most notable ones is if you apply to be a police officer, we know that. I believe like a corrections officer, anything that is criminal justice certified, certainly anything where you would be required to carry a firearm for your job, I think would be required for that. I don't have an extensive list of every job that that has the ability to see that, but I would say for state employment is where you get into the area where you an agency might be able to see your expunged records. Also, if an agency requires that you disclose expunged records on your application, then you would be required to do that.
Perfect. Someone's asking if I guess they have convictions in North Carolina, but they no longer live in North Carolina. Can they do the expunction process in their current state, or do they need to travel back to North Carolina to handle it?
The short answer is no. You can do that from where you are. Most clerks' offices will accept petitions by mail, so you can mail them in. If a hearing is required for your expunction petitions, in that case, you may have to travel back for sake of that hearing, or you may be able to contact the court and ask them if they could do that hearing via some sort of web platform. That would be when you would have to come back. But most clerks' offices will accept petitions either e-filing or by mail. It's also, again, that's a good time to possibly contact an attorney that might be able to appear on your behalf if there is a hearing. That's it, at Legal Aid. If you are a client of ours and we file your expunction petitions, then we appear on your behalf at your expunction hearings, unless the district specifically requires the petitioner to be present at the hearing, but that's not so many.
Where can someone get a complete copy of their criminal record?
Okay, so North Carolina has completely gone to eCourts now. It's Portal or Odyssey. You can go online and you can sign up for an account with North Carolina eCourts, and you can search your own record. It's important to search any names that you've ever had, any aliases that you've ever used, anything like that. You make sure you search all of those to make sure that you get everything. You can also access eCourts through, they have a terminal, I believe, in all the clerk's offices or near the clerk's offices in every courthouse in North Carolina.
Okay.
You can, let me add to that. If you wanted a copy of your SBI record, you can again order that from them online, and also an FBI record online, but not everything is on that. Those are offenses that usually where you were either arrested or required to get fingerprints for.
Um, is something an expunction? Is an expunction something? La 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 la. Is an expunction something someone can do on their own? Is an attorney required?
An attorney is not required. You can absolutely file your own expunction paperwork and sign those petitions yourself when you submit them to the court. The more convictions that you have on your record, and the more lengthy your record is, I would say the more important it is to consult with an attorney before you try to file those petitions. Again, as I was saying before, there are situations where if you don't file things, you could become ineligible to file them in the future. That would be, I would say, the biggest risk. But also, you just want to make sure that you are not, say, spending a bunch of money to file petitions that are incorrect, that you're not eligible for. If you have convictions in 3 different counties, in district and superior court in 3 different counties, and you're planning on paying a $175 filing fee for each of those petitions, that adds up pretty quickly. So you want to make sure that the petitions that you're filing are not ineligible for the convictions that you have are not ineligible for expunction, and you're not just wasting that money, or like I said, preventing yourself from being able to expunge just in the future. In that case, it might be really worth a consultation with an attorney to find out exactly what your eligibility is, and let that attorney look over your full record.
Um, I think the best way for me to ask this question is no, don't know how to ask it, so I'll come back to that one. Let's see. Da-da-da. To those of you with your hands raised, again, we cannot unmute in this forum, so if you have a question, you need to put it in the Q&A box. And again, we cannot respond to specific questions, so for all the questions asking about specific offenses, we will not respond to those. I think some people might have missed the presentation. So someone's asking, how can they expunge a dismissed charge that was before December 2021?
You would go to that link that Marissa, you put up in the chat there, and find the correct form for petition to expunge dismissed charges. And then you would fill that a petition to expunge dismissed charges out for the court, the county and court, either superior court or district court in which the dismissal occurred. And then you would file it with the county clerk of court's office in that county.
Okay. What reasons, this is a new one, would a judge maybe deny an expunction petition? And if an expunction petition is denied, is that denial appealable?
Wow, that's a good one. All right. So, okay. So, there some types of expunctions are per the statute, by the statute. There are certain types of expunctions that are mandatory for the judge. The judge shall grant, and there are certain types that are discretionary. If the statute makes the offense, if the statute it is one in which the judge has discretion to grant or deny the petition by their own discretion, then the judge can grant or deny that petition for any reason possible. They could, maybe they don't like to grant expunction petitions. Maybe, those are often the ones that will require a hearing where the petitioner would be required to be present. It could be, they might ask questions about what you're doing now, what you've done since these convictions occurred to turn your life around. That again is completely in the judge's discretion. If a judge denies a petition that was completely within their discretion to grant or deny, I do not believe that is necessarily grounds for appeal. You would have to have some other legal reason to appeal that petition. If the statute requires that the petition is granted, if the petitioner has met all of the qualifications and they do, then you could potentially appeal that. Though honestly, I'm not aware of very many appeals happening in the world of expunction.
Okay.
Does that
Perfect.
does that cover
I
it?
think I think that about covers the best we can. So what's the is there?
Yeah, that's a pretty tough legal question and would require some very specific advice on what was happening with the petition.
Got you. I think someone's just asking for clarification regarding the disqualifying
Okay.
convictions regarding, I guess, drug dealing charges, I think. And I think the question is asking if they have if they have other felonies that technically would be expungible, if they have those disqualifying drug charges, those are not, that makes them all unable to be expunged. Right?
That is
And you
correct.
probably say that better than I can.
No, you're fine. I can clarify that. Okay. When it comes to drug charges, any charge that has anything to do with crystal meth or heroin is disqualifying, and that means that you cannot expunge that offense or any other offense on any other conviction on your record. A conviction for as far as cocaine goes, simple possession of cocaine is not a disqualifying charge, but as soon as you get into anything more elevated involving the possession with intent to sell or selling cocaine, those become disqualifying. There are marijuana felonies that are not disqualified or disqualifying. But the answer to that question is that if you have been convicted of if you have been convicted of a drug offense that is not qualified for expunction, then that offense is also going to cause your other convictions to be disqualified.
Okay. Next question, and I think you might have answered this one already, but in a situation where someone, I guess maybe it was one instance and there were multiple charges, but it only ended up in one conviction, does that person have to expunge all of those charges, or is it only the one conviction that would be potentially expungible?
It depends on how it happened, but if you had, say, you were charged with 3 different charges and 2 of the charges were dismissed and one of the charges you were convicted of, then you would need to file 2 separate petitions. One petition to expunge the conviction and one petition to expunge the dismissals. Just expunging the conviction would not take care of the dismissed charges automatically. Now, if you were charged, let's say you were charged with possession with intent to distribute cocaine, and you were found guilty of only possession of cocaine, if you were found guilty to a lesser offense, then you would only need to file a petition for the conviction because the other charge was not dismissed, it was just reduced.
Can arrest records be expunged?
So when you get a charge expunged, you fill out on the petition all the agencies that were the arresting agencies, and those agencies, if the petition is granted, that petition is sent to those agencies, and those agencies are supposed to remove your arrest records. That does go under the same thing advice I was giving about some agencies will still be able to see those, and those are the same agencies that would still be able to see the expunged conviction.
Okay. We will talk about accessing legal aid in a few moments here when we get closer to the end. Uh, let's see. Oh, another new one. In a situation where the charge was ultimately dismissed or the person was found not guilty, but I guess maybe they're in that 6-month waiting period, and I guess it's still showing up during those 6 months, so there's that it's causing issues for employment. Is there anything that can be done regarding that potential lost income? Don't know if that's something you can answer at this time, but it is new.
I'm not really sure if about like something being I don't know what would be done about the lost income. I don't, if you wanted to expunge the dismissal sooner than the 6 months, you could always file a petition to expunge the dismissed charge as soon as it gets dismissed, and that may get it expunged sooner than the end of the 6 months, for the automatic expunction. But as far as, like, any sort of suit for damages for lost employment, no, I do not believe that's a thing.
Perfect. And then another clarifying, if someone's like filling out a job application that is ever asking if they ever pled guilty or no contest or anything like that, but they have an expunction that was granted, record white clean, they could confidently answer no to that question.
Once you have
For
been granted
something where an expunction has been granted. Ask that a little too specifically.
Okay, for a charge where you have been granted an expunction, you are entitled to say that the charge never happened in any situation unless you are specifically asked to disclose expunged charge.
Okay. Do you happen to know the statute number for the
For
list
which,
of ineligible offenses? I might have a copy here. Hold on.
so
Oh wait, no, I
every
got it.
Oh, there we go. So every statute, every different statute though has a little bit different portion of that. It's usually the first portion of the statute. So for convictions, it is for just regular adult convictions, the statute is North Carolina General Statute 15A-145.5. Um for the um for the convictions before raise the age at 16 and 17, it is 15A-145.8 or 145.8A. And then there are some other like kind of niche statutes like the like offenses committed by human trafficking victims or gang related offenses. That those are not the more generally used statutes.
Okay. And I put a link to chapter 15 or statute 15A-145.5.
Perfect.
Yes. So for those of you who are asking, some of these questions were answered during the video. The video will be made available after this presentation, so I think it might be easier to just rewatch the short video that played. Okay. Okay. I don't think, let me check Facebook. Don't think we can answer any more of these. Hold on. Someone said a link doesn't work. Which link is the one that doesn't work? I'll try to get the right one. Okay. What was I about to ask you? Are there any limitations on who is allowed to ask about or ask a person to disclose their expunged convictions? Can like potential employers ask? Can medical providers ask? What's some information there?
Um, I don't know the answer to that question. I'm
Sounds good.
sorry.
No problem. Okay. Again, we cannot tell you whether or not your specific charges can be expunged. That is a specific legal question. We cannot respond to that in this forum. Okay. Um, are you familiar with the Second Chance Act? I have someone asking you to explain that. Is that something you could do in like 2 or 3 sentences? If you're familiar?
The Second Chance Act is like kind of encompasses a lot of the whole expunction and post conviction relief. That's not something that I could explain in a couple of sentences now.
Okay, then yeah, no, we will let that one alone. Yes. Is AI Do you think AI is a suitable resource to utilize throughout the expungement process for someone who can't access an attorney?
I'm
Is
sorry, can
AI
you
a
repeat?
helpful tool?
It, I would not. Let me just say it this way: I would not trust AI to give me legal advice on anything.
Okay. And think. Okay, that might be something. Oh, someone's asking for the exact website for eCourts. I will post that in the chat. The website for eCourts. They stated in video by age, but wasn't understood. Don't understand some of these questions. So I'm just gonna go ahead. I think this question is asking that a felony when the person was 16 could potentially be expunged. Yes or no?
It depends on what the felony is.
Okay, that's what I figured. Uh, okay, so yeah, I think that's everything. Everything else I'm seeing is too specific or is not an actual question. Oh, okay, here's one. How do you know if expunging the conviction, or how do you know? I think this is asking which petition is right, or how do you know if an expunction is right for you? There are two different ways to read that question.
Huh. Well, so if you're asking which petition, it would depends on what kind of offense you're trying to expunge. So dismissals are one type of petition, not guilty charges are one type of petition. The convictions committed before raise the age at the age of 16 and 17, that's one type. Nonviolent misdemeanors is one type, and nonviolent felonies is one type. And then there are different types for the other like weird little expunction laws that I was saying before. How do you know if an expunction is right for you? It depends on if you're qualified and if you are ready to expunge if you're ready to use your one shot expunction convictions if you're attempting to expunge convictions.
Okay. And I think now we have mainly people asking about ways they can contact legal aid for potential assistance with expunction. You want to talk about that a little bit, Trina?
Sure. Now, what you would do is you would call the legal aid helpline and for ask for an expunction file to be open for you. I am not sure right now when we are going to be doing open intake and when we are not. So the best thing to do would be to call our helpline and to ask for an expunction file and go through the intake process to see if we are accepting files or not. If we do open a file for you, what we'll do is we'll take your information. If you qualify for legal aid as a whole, that is by income. So if you are overall qualified for legal aid services based on your income, and we do have open intake and second chance to open new expunction files, what we would do is we would get your information. We would run a criminal background check for you, like to get your entire criminal record, because that's like one of the most important pieces. We would analyze that we would then call and confirm that record with you to make sure that we have everything, that we don't have things that aren't you, and that there aren't things that we have missed. Then an attorney would review that record and tell you what your eligibility is, like which charges were eligible for expunction and which charges were not, and advise you on that record. In some cases, we would draft petitions for you and send them to you to file for yourself. And in some cases, depending on your file, we would file as attorney of record in your case. Does that answer that question?
I think so. I think that
Okay.
does.
Okay.
And for those of you who might be wondering, maybe I don't qualify for legal aid, or it sounds like at least right now, legal aid might not be doing intake. I did put a link to the North Carolina Law Referral Service. This is a service run by the North Carolina Bar Association where you can find attorneys who would be willing to do a consultation with you for about 30 minutes for about $50. So for those who might be looking for that kind of assistance. We do not
Thank you
know if
for.
public I'm sorry, what was that?
No, I just said thank you for putting that in there, Marissa.
Oh, no, no problem. Um, I don't know the answer to this. Do public defenders help with expunctions?
No, they do not.
Okay, perfect. Okay. So it does not matter the date of the offense. Okay. Uh, So, and again, it's asking about if they've got felonies or misdemeanors. I guess they got convictions in multiple states. Would they need to be filing in each of those states, or is that something you can answer?
I'm sorry, can you repeat that one?
I'm sorry.
No, it's
Someone's
okay.
asking if they have convictions in multiple states, which could include North Carolina. Do they need to file an expunction in each of those states where they would qualify, or can they
Um,
just do it all in one state? I guess is the question.
so first of all, every state handles expunction differently, and many states do not have expunction. Some states seal records, some states will expunge charges, and some states do not have statutes for any at all. In any case, um, y- you would have to expunge those charges in the state where they occurred. And most likely, if that state has an expunction statute, you would have to file wherever that statute requires you to file in whatever districts. However, of course, I'm a North Carolina attorney and I'm not licensed in any other state, so I can't advise on any kind of out of state expunctions.
Okay.
But I can't file in North Carolina to expunge charges that occurred outside of North Carolina.
Can you talk a little bit about the difference between sealing a record and expunging and expunction?
Um, you know, some states just seal a record so certain people can't see it. That's my understanding of that. North Carolina does not do that for any kind of offenses that would show up on a regular record. We do expunction.
Okay.
I think
Um,
there may be like for some juvenile offenses records that are quote unquote sealed, but I can't actually answer that question. But for
okay.
any of the offenses that we are talking about that show up on your criminal record background check in North Carolina, the expunction is the process that we use for post-conviction relief in the way of removing those charges.
Okay. 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 I'm sorry. It's a lot of questions coming in at the same time.
No, you're
And then I
fine.
think just some more clarification about the timing, if you just want to state that answer again for how long it takes for something to be granted once filed.
Again, that is extremely variable depending on where you're filing. Some places take a week or a couple of weeks. Some places take over a year. It just depends on how quickly the court process moves in whatever district you're filing in.
Okay.
It also can depend on what kind of charges. Dismissals generally take less time, but that can also vary wildly depending on where you're filing.
Okay. Um, and then I think you talked about this already, but the timing for whether it's a misdemeanor that you're trying to expunge or a felony that you're trying to expunge, just reiterating those time limits one more again.
Okay, so you mean like for the waiting periods? Is that what
Yes, I'm
that
sorry.
no,
Yes.
you're fine. No, I just want to make sure I was answering the right thing before I went into it. Okay. So again, this depends on in order to assess how long your waiting period is going to be to expunge charges, you need to look at the entire record as a whole, not just each individual offense. If you are petitioning, if you only have one misdemeanor that you're ever going to petition to expunge, one misdemeanor conviction, that is the waiting period for that is 3 years from the date of the conviction. If you are petitioning to expunge multiple misdemeanor convictions, the waiting period is 7 years from the completion of the latest sentence. One nonviolent felony is 10 years from the completion of the sentence. Multiple, and I think you can only do 3 nonviolent felonies would be 20 years. But then also with felonies become ineligible if you have more than one and they were disposed farther than 24 months apart from each other. The other important thing about this is I would want to state that you only get one chance in North Carolina to expunge convictions. So you would not want to expunge one type of conviction before all of your convictions were eligible, because you would use that chance before you were able to expunge your conviction.
Perfect. And do you file in the county where you were convicted or in the county you were charged? If those are different counties.
I would think that you would be charged and convicted in the same county. Like you would get charged, and you would get charged. You would go to court, and the disposition of the case would happen where the charge happened, I would think. I don't know that I've seen a situation where somebody was charged with an offense in Wake County and then, went to court for that offense in Durham County, and that's where the conviction occurred. I don't, maybe I'm not there. Maybe there's something I'm missing there, but I'm not aware of that situation.
Okay. And then, okay, yeah, I think you just answered that. And then this last one, don't know if this is something you know. Can mugshots ever be removed?
Oh gosh. So the short answer is no. And I've had this question before, and okay. So if the mugshot is part of it, if you're talking about the mugshot that's actually part of your file, like your arrest record, then when you petition to expunge, then that will be that should be removed. However, in this great day and age of internet technology, if you're talking about a mugshot that has been pulled from the public record and put into some sort of like internet publication for crazy mugshots, once that's on the internet, there's no way to like expunge that off the internet. You can't require that someone remove that from their database. I do not believe. I suppose that sometime in the future, someone somewhere could try to ask somebody to do it, but I'm not aware of that. And as a practical matter, as we all know, once a picture is on the internet, and it can be copied and you know disseminated in all different types of ways. So unfortunately, I don't think that there's a way that you could ever ensure that that was going to be removed in that way. Again, though, if the actual shot that is part of your arrest record would be removed when the expunction was granted, or you know, expunged the same way the rest of the arrest record would. But again, once that once that mugshot has been pulled from the public record and used by private companies and no, I don't know that you could do that. I know that I've had clients that have had that situation.
Okay. Oh, and here's a clarifying question from the multiple county thing is I think someone's saying that their conviction was in a different county than the county they're currently living in. Could they file in
Oh,
the county they're currently living in, or do they have to go back to the county that makes more sense? That was my fault.
yeah. I was wondering if that wasn't a question. Maybe. No. You must file the petition in the county where the conviction or dismissal occurred. You cannot. Yeah, you have to go back to that county. Or you may not necessarily have to go there. You might be able to file it by mail or electronically file it, but it would need to be filed to the clerk's office in that county.
Um, okay. This is a different one. Uh, Someone's asking if there's a felony in North Carolina and a misdemeanor in another state, but they're only looking to have the North Carolina felony expunged. Would that misdemeanor in that other state also need to be expunged, or could they just focus on their North Carolina conviction?
So you don't have to expunge something in another state, but whatever that conviction was in another state could affect your eligibility in North Carolina. For instance, if you were convicted of an assault offense in another state, that might affect your availability, your eligibility in North Carolina. So you would need to that's another situation where I can't really give you a specific answer, because I would need to know the exact offenses and the exact time frames and what your entire record looked like.
And then last one, is there a keyword someone should type in when they're on the NC Court site? I guess to get to the forms, any keywords they should probably use,
Um,
like
ex-
maybe type in expunction or something.
Petitions to expunge or expunction,
Perfect.
I would think. I would think.
And then how do you feel? I know you mentioned how you feel about AI. How do you feel about things like LegalZoom or those kind of more online, not AI, but online legal resources in terms of their ability to assist someone with an expunction?
I don't know the answer to that question. I know that LegalZoom, you know, there are actual lawyers working there, I believe, but I don't know how to answer that question. I don't know if they do expunction or how qualified they would be. I've never had any interaction with that.
Okay. Okay. Yeah, someone's saying they're clarifying, but I don't know what that means. Just to clarify, the convictions were 6 months before. Yeah, I don't know what the question means to ask it. So I think I'm gonna say now. I don't think we can. Oh wait, no, I'm just gaming. I think I can now say thank you all for joining us. So we know the question comes in the next 2 seconds. With a special thank you to Triner for answering all of those questions for us. Again, if you would like to review anything that Trina discussed today, or if you would like to rewatch the video that was played at the beginning, a copy of this event will be posted to our Facebook page. It will be immediately available. You can access it with or without a Facebook account at www.legalaidnc. I'm also going to put a link to the chat for those of you who have other questions or other ideas about Listen and Learns, or if you just want to share some feedback on this specific presentation, you can do so at the link in the chat. If you'd like to register for one of our other Listen and Learn programs, can't answer that. Okay, last question. Can you file for an expunction online? I think we answered that, but just want to get it one more time.
An expunction petition can be filed online, but it has to be filed in eCourts by somebody who has an eCourts account.
Perfect. If you'd like to register for one of our other Listen and Learn presentations, such as child custody, simple divorce, we also now have a fair housing Listen and Learn. You can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their afternoon.